All right, Dave, you ready?
I'm ready.
All right, everybody, this is Dave. Dave, thank you for giving me your time, or us your time. I really appreciate it. I mean, I have wanted to do this for so long. I just feel like on the real estate side, I would say we have 80, of all the people who pass away and, they wind up in my hands to go sell the properties, I would say like 90% of them wind up in probate. Meaning there's just such a few percentage of people who have taken the steps to set up a trust, and I've just witnessed what happens on the back end of that if you don't have that set up, and it's just such a mess. If you own one home and one bank account, it's not that big of a deal, but if you have multiple bank accounts, or let's say people have to make medical decisions for you, and you're incapable of doing that, with the rise of dementia and long-term care, I just have seen so much time and energy, and it like really hurts families, and it creates these barriers that kids have that we can't make decisions for our parents. And so I've witnessed it a lot, and so I wanted to do this for like 3 or 4 years. We just never have done it. So I'm excited, Dave, that you gave us your time. Dave was introduced to me through my CPA, actually. And my wife and I went through the process of getting a trust through Dave. It's very simple, very easy. I'm not done with my end of that bargain yet. We've dragged our feet. And that's actually one of the questions that I think you should shed light on is you need to actually do the steps and finish the trust, because I'm not even taking my own advice in that fact. I've met a lot of people who have trusts, but they're very incomplete, and it doesn't actually serve the purpose it was designed for if you don't put everything into the trust. So, Dave, that's my little spiel.
All right.
I'm here to learn as much as you are. So, I wrote the questions down for you, and you just do your thing.
All right, let's do it.
Dave Morris. I forgot to say his last name.
I haven't done anything yet, you don't have to clap. Yeah. But thanks for coming, you guys. So yeah, like you say, my name is Dave Morris, and I'm an attorney, and I've been an attorney for almost 25 years now, certified specialist in trust and estates. The name of our practice is Morris Law Group. We have an office in El Dorado Hills, and this is one of our main areas of business. So have any of you guys ever heard me speak before?
Heard what?
Heard me speak before. So I do presentations like this periodically, but I just didn't want to have you hear the same thing twice. But yeah. But anyway, so today we're going to talk about estate plan, and of course, the key thing on that is a trust, but we'll talk about that in a couple of minutes. But let's take a look at these, make sure we're heading in the right direction. So what is a trust? Why is it important? Costs, irrevocable versus revocable, types of trust, multiple owners, non-profit trust, AB trusts, residency, entity versus individuals, and tax protection. Okay, I think we can cover all that stuff. So, all right. So this is kind of an informal group, so I'll probably sit down for a little bit, and but I like to walk around. I'm a big gesture guy, but yeah. So when we talk about estate planning, now, so just so I'm kind of on the same page, you guys are all real estate professionals of one kind or another, right?
No. We have actual
who we
clients
got?
in the room too.
Real life clients. Okay,
Yeah.
so that's cool. So so of course the interesting thing about that is that means that everybody's kind of coming at this from a little bit different level of knowledge, a little bit different level of understanding, a little bit different level of experience. And so I'm going to kind of start with the basics, because I don't want to start like on step 3 and have people being like, what the heck is he talking about? So so let's just start at the basics. Okay. So when we talk about estate planning, which is sort of the general rubric for all of the stuff that we're talking about, the main idea behind estate planning is just to make sure your stuff goes where it's supposed to go as quickly and cheaply as possible after you're gone. Okay? And it has a secondary benefit, if you do things right, of taking care of things when you don't die, that something bad happens to you. You have a heart attack or a stroke, you develop dementia, you get in a car crash. Something like that happens, but you don't die. In some situations, if you don't have a good plan, that's actually worse than dying, because some of the things that they have available for those situations are even worse than going through a probate, which we'll talk about in a couple of minutes. Okay? So when we look at our estate planning options, we essentially have 3 basic basic options. Any guesses on what the first option is?
Do nothing.
That's option 2. What?
Do nothing.
Do nothing. That's right.
No choice is a choice.
Right. What we always tell clients is, if you don't have a plan, the state of California has a plan for you. Okay? And they call those the Intestacy Laws. If you die without any testamentary documents, without a will, without a trust, without anything else, that's called being intestate. And so there are a whole bunch of intestacy laws. They're all baked right into the California Probate Code. Every state has intestacy laws, and on almost every state, they're basically the same. So the idea is that if you pass away without a plan, then the default idea is that if you're a married person and everything that you own is community property, everything's going to your surviving spouse. If you don't have a surviving spouse, or if not everything you own is community property, then things start to get a little bit messy. If you don't have a spouse, then the default is everything's going to go down to your kids in equal shares. If you don't have any kids, then we start getting a little confusing, because then what happens is it starts going out to what we call your heirs at law. And there's a thing in the law called the table of consanguinity. Those are the people who are related to you by blood. And so normally you're going to have kids, grandkids, great-grandkids. If there's anything down there, it goes up to your parents, up to siblings, nieces and nephews, grandnieces and grandnephews. Every once in a while you read in the news about somebody who just inherited like 10 million bucks for like a third cousin that they didn't even know. That's the intestacy laws in action, okay? So that's our backstop. There are definitely rules for where your stuff's gonna go. It's not like a person ever passes away and everyone's like, I guess it's not going anywhere. So one of the common misperceptions that people have is that your stuff might wind up going to the state. Now, the state's definitely gonna take a chunk of what you've got if you don't plan right, but they're not gonna get your stuff necessarily. I mean, I suppose the only time that that might wind up happening is if a person didn't have like any blood relatives that, you know, who even knew what was going on. There's a certain point at which the state might like seize the assets, but even then, what they do is they keep them at the California Controller's Office has basically a division of unclaimed property. And so sometimes they'll go and they'll clean out bank accounts, they'll hold a piece of real estate, but they're technically holding that in trust for the eventual people to show up. Sometimes they never show up though. So
There's a website you can actually search your name, and I mean, I found $37 this year, so I don't know where we found that. Maybe someone returned it, and dropped my.
Oh yeah, it can be all kinds of weird things. So, it's kind of interesting. Just as a side note, the California Controller's Office actually got sued a few years ago. We're talking like 10 years ago, and part of the reason for that was that they had hired an outside consulting company to take care of like getting a hold of unclaimed assets, and they were very, very aggressive about that. And there are some famous cases where there was a guy, for example, he worked for, I think he worked for Intel or just, you know, some other company. And, you know, of course, if you work for Intel, you know, sometimes you get sent off to the other side of the world for 5 years. He did. And he came home after that to discover that he had had a safety deposit box. And in that safe deposit box, he had a bunch of stock certificates. And this consulting company hadn't, you know, I mean, their rule was if an account hadn't been touched for 3 years, they were going to deem it that account was to be closed and those funds were to be held by the controller's office. They were super aggressive about this. So they actually grabbed these stock certificates, sold the stock, and then put the money into an account to say, okay, hopefully this guy will show up. You can only imagine what happened in the interim. This was stock on like a closely held company that then skyrocketed in value. Like we're talking like 10 or 15 times value. Meantime, these guys are sitting here holding this in a savings account, making like 0.5% interest. This guy gets home, and you can imagine how he felt about that. So, you know, because they had sold the stock, and then it had just sat there, basically not even keeping up with interest or with inflation, and it should have been worth many, many multiples of what it originally was worth. So he sued, and a whole bunch of other people sued. So they decided they weren't going to do that anymore. But anyway, so that's the thing. Yeah, it was crazy. So, but anyway, so those are our backstop rules. There's the intestacy laws. Now, like somebody had said just a second ago, our second option is to do a will. Okay. Now, a will is a letter of instructions, and the nice thing about a will is it lets you opt out of the intestacy rules. Let's say you don't want to leave everything to your spouse. Let's say you don't want to leave everything to your dumb kids. Maybe you want to leave stuff to a charity or your church or to a friend or whatever else you may want to do. With a will, you can come up with your own customized plan. And generally, those things will be honored unless you're trying to do something illegal. But, you know, so you can totally opt out. of the backstop rules. If you don't want to go with the intestacy rules, you can come up with your own plan. The other nice thing in a will is you can put conditions on gifts. You could say, I'm going to leave this stuff to my kids, but only if they graduate from college, or only if they get married, or whatever else you may want to impose on your kids. You have the right to do that as a condition of making a distribution with a will.
That could be an age.
It could, oh yeah, definitely.
Yeah.
That's a very common thing.
Yeah,
Because of course, the default age for distribution in almost every state, in fact, every state I'm aware of, is 18. And you think about a lot of 18-year-olds, maybe that's not such a great idea. So, like on a lot of the documents we draft, we bump that age up. So we'll talk about that a little bit. So anyway, do nothing, do a will. If you choose to do either of these things, then the biggest problem that your estate is going to face is that your estate's going to have to go through what's called probate. How many of you guys have heard of probate? Okay, so it's a pretty common thing now. It used to be like back when I started doing this, I'd come into a room like this and like maybe one or two people would put their hands up, and it was almost always because they'd had to take mom's estate through probate or some other thing like that. So probate is a court proceeding. The court steps into the shoes of the deceased person, gathers up all that person's stuff, and then distributes it, either according to the intestacy laws, if there's no plan in place at all, or according to the terms of the will. Okay? So that's why we like to describe a will as a letter of instructions. It's basically just a letter of instructions to the probate court. A will doesn't have any real legal effect outside of probate, unless you have a very small estate, which we'll talk about in a couple of minutes. But so if you don't do anything, your estate's going to probate. If all you have is a will, your will has to be probated. Now, probates serve an important function in society. It's an anti-fraud measure. It makes sure people get notice if they're supposed to be beneficiaries or potentially heirs of law. It's a place where creditors can show up. If somebody dies and maybe they owed you $100,000, that gives you a venue to come and submit that claim to make sure it just doesn't dry up and blow away. Okay, but probate's generally something we're trying to help people avoid. California is kind of notorious for having the worst probates in the country. Okay, we do probates as part of our practice, but our whole goal is to keep people outside of probate. The main reason for that is that it's a court proceeding. Court proceedings are very expensive. Probate fees, which are the fees that are paid to the attorney who does it, and also to the executor of the estate, are based on a percentage of the gross value of the estate. Okay?
Really?
Oh yeah.
Whoa.
So
Can you
yeah.
repeat that, please?
Okay, so probate fees are generated based on a percentage of the gross value of the estate. It starts at 4%. So it's 4% of the first $100,000 of gross value, 3% of the next 100, 2% of every 100 after that, up to about $1.5 million. And then they have another formula that they use for larger estates. So what I always tell clients is, let's say that you had an asset that's worth $300,000. To take that through probate, it's going to cost you 4 plus 3 plus 2. It's going to cost you $9,000 in probate fees. And if you also have an executor who's collecting fees, you can double that. So you're looking at almost $20,000 in probate fees. And if we're talking about a real piece of real estate, all you're doing is having the probate court rubber stamp the deed. It's not like they're doing anything.
House.
Yeah, exactly. Yeah, exactly. Maybe it's a piece of, maybe you could find a lot for that.
We're not in South Carolina.
Yeah. So
Those,
yeah.
what are those fees again?
Okay, 4% of the first 100, 3% of the next 100, 2% of every 100 after that, up to about $1.5 million. It's basically 2% of the next 800. And the important thing to remember here is it's based on the gross value of the estate. So we're not talking about the net. So let's say that you've got $1 million house with a $950,000 mortgage on it. You're not paying the probate fees on the little sliver of equity that's there. You're paying the probate fees on the full fair market value of that piece of property. Okay. I mean, we've actually seen situations, we haven't seen in a long time, but back in the day, maybe some of you guys remember we had a recession once upon a time. There were times where people would come in and it turned out that they had a piece of property that was either underwater or there was so little equity there that by the time they had to pay the probate fees and take care of all this stuff, there was nothing left.
They were upside down.
Yeah, they were upside down.
Is the same could be said for like 401k accounts and things like that are left over? Is that same kind of?
If it has to go through probate, then those things are all part of the countable estate. So yeah, we're not talking about just real estate. We're talking about
All
vehicles, we're talking about bank accounts, we're talking about pretty much everything else. I had a question here, then a question
And
here.
those percentages, are those court fees or are those like a negotiable fee?
I mean, theoretically, they're negotiable, but those are statutory fees. Those are in the probate code. You know, you might be able to find an attorney who would do it for less than that, but we're not required to do that. And quite frankly, I don't think I know anybody who discounts fees, you know, just because probates are a giant pain in the butt. So yeah, another question.
To be clear, so you had mentioned earlier that a will is a letter of instruction to the probate court, so that does not avoid these fees.
100%.
Correct?
Yep. Yeah. A will is a one-way ticket into probate. So, yeah.
If you have beneficiaries listed
Mhm.
on all of your bank accounts,
Mhm.
your real estate property,
Mhm.
is there any point to really having a will go through probate if it's just little stuff left over?
Well, probably not. So let's talk about ways to avoid probate. We'll jump to trusts in a minute, but let's talk about non-probate transfers, because there are ways to do that. The number one of which is what you just mentioned, which is a beneficiary designation, okay? You can put a beneficiary designation on almost any kind of account that I'm aware of. You can put it on a checking account, on a savings account, on a brokerage, you can put it on a 401k or an IRA, you can put it on life insurance. Beneficiary designations make it so that that is a non-probate asset, okay? It makes it so you can transfer that asset down to the beneficiary without having to go through probate, okay? So
And is that outside the will?
yeah, and in fact, if the will contradicts what the beneficiary designation says, the beneficiary designation wins. Wow. And the reason for that is the beneficiary designations have their power through what's called Arisa, which is a federal law. And wills and trusts are creatures of state law. And if you remember back in high school when they talked about the supremacy clause of the United States Constitution, basically federal law trumps state law. So you can imagine a situation where you had a will and the will said, all of my accounts, wherever they go, are going to person A, but on your actual accounts, you would put beneficiary designations and everything was going to person B. All that stuff is going to person B, even if the will came after the beneficiary designations, okay? So one of the things that's super important when you're putting together a good, well-crafted estate plan is to make sure that these things are congruent with each other. You know, you don't want it to be the kind of thing where you got some stuff that's sort of going over here and some stuff that's maybe going over here and they're in conflict and now you got a big fight and that's bad. You don't want that to happen. Okay.
Also,
Yeah.
one of the reasons that I just recently learned is when you're the beneficiary, you inherit the tax base.
Mhm.
So if you've got your name, the beneficiary as Ada on your stock account, and I have a will and I'm saying I want 50% of that stock to go to her two kids, but Ada's the sole beneficiary, Ada inherits it, and if she goes and tries to transfer it out of that account to the other two kids, they don't get the tax base on it.
When you say tax base,
The original tax base of what the stock was purchased at.
oh, you're talking about basis.
Uh-huh.
Yeah, okay.
So that really gets squirrely within all that.
Yeah, I mean, it's actually a little better than that, you know, because the step up, so we're talking about a step up in basis.
Well, so the accountant said that then she has to declare that as a gift,
Mm-hmm.
and it goes against her lifetime of a gift estate.
Yes, those are two totally different types of tax.
Yeah.
So yeah, but yeah, I mean, we're gonna talk about tax in a couple of minutes, but yeah, I mean, we basically, anytime we're dealing with this kind of stuff, we have like 5 different kinds of taxes to worry about. You know, I'm sure all of you guys as real estate folks are well familiar with property tax and other things like that, but yeah, this gets pretty slippery pretty fast, yeah.
So you have your real estate ownership.
Okay.
Is there a way to put a beneficiary into that real estate
Okay,
situation?
so there are. One of the things that California has come up with in the last few years is basically a pay on death designation on a piece of real estate. We don't generally like to use those. And the main reason for that a lot of people don't know, is that if you put somebody on as a beneficiary on one of those things, not only do they receive the property when the person passes away, but they also become personally liable for any of the obligations that are associated with that property. And that's a huge bummer. Yeah, that's one of the things that's really remarkable to me, yes.
Like mortgages and taxes.
Taxes.
Well, actually, on top of that, there's actually some authority to the effect that maybe it's all of the personal debt of the deceased.
Credit cards,
Yeah.
anything.
Yeah.
But if you have no mortgage, then it would just be property taxes.
Yeah, theoretically. Mhm. So, yes.
If I can add to that, I recently had a transaction where there was a mom who recorded a transfer on death
Mhm.
deed to her 2 kids,
Mhm.
and
one of the two kids passed away before, right after she did. So it went from her to her two boys. One of her boys passed, so the boys' daughters ended up having to still go through probate because they didn't have anybody assigned, so it defeated the purpose of her doing that. They still had to go through the entire process. And they had to pay capital gains on top of that because now they were the owners of the property and they were never, it was never their personal residence. So it just kind of became this big mess.
Okay.
And then once it goes to probate, it can be contested by any outside person, right?
Theoretically, contesting a document like that, contesting a probate, contesting a will, is actually a lot harder than a lot of people think. You can only contest a will or a trust for 4 reasons, almost, all of which have to do with the creation of the documents. Those rules are fraud, duress, lack of capacity, undue influence. Fraud is somebody tricked grandma into signing a deed, or tricked grandma into signing a trust, or something like that, or a will. Duress is somebody held a gun to her head and forced her to sign it. Undue influence is like the classic situation is grandma's got a caregiver. Caregiver insinuates himself into the situation. All of a sudden, grandma's leaving the house for this caregiver, right? And then lack of capacity, Alzheimer's, dementia, substance abuse, something where they don't have their full mental
But
capacity.
you'd have to prove that.
Oh yeah, you have to prove that with clear and convincing evidence. So it's a big uphill battle. So yeah.
And you have to prove that, for example, lack of capacity at the time the trust or the will was created?
Yes.
Not when they.
No, it's not
that they
subsequent.
passed it.
Yeah, because you can imagine a situation where they created documents. They went on with their life for 10 years, and maybe they had dementia when that person passed away, but they had created the documents when they still had full capacity. And so those documents should still be just fine. Okay. So, I lost my train of thought there, but anyway, so probate is not something that you want to have to go through. You want to avoid probate if you can. There are a variety of ways that we just talked about that will avoid some of the things with probate, but the problem with a lot of the things that we just talked about is sometimes the cure is worse than the disease, okay? Sometimes you've got a situation where you have a person who has some bank accounts or who has some life insurance or other things like that, and they leave it to a person, and then the person who left, who's the person who's leaving it to the person passes away, and it turns out that the person that they left all this stuff to is in the middle of a bankruptcy, or is in the middle of a lawsuit, or in the middle of a nasty divorce, or an IRS audit, okay? So the big problem with beneficiary designations is it's like you were alluding to just a second ago. They're like an on-off switch. The only thing that they can do with a beneficiary designation is cut a check to the beneficiary, and that ownership interest accrues the moment the other person dies, okay? So like your situation you were talking about, as soon as mom died and it was supposed to go down to this child was, subsequently died. So, but it passed to that person the moment that mom passed away. So it was part of this person's estate, okay? But the other problem is, what if instead of dying, he was in the middle of an IRS audit or was in the middle of a bankruptcy, All they can do is cut a check, or all they can do is turn over that asset to that person, which means in a lot of those kinds of situations that asset is going to get seized right away.
Unprotected.
Yep, it's totally unprotected. So we'll kind of talk about how to deal with that, okay? So we're not super big fans of beneficiary designations for that reason. There are better ways to do that, which we'll talk about in a second. But those things will definitely avoid probate. And of course, it's not my goal to scare you or to say, oh, all these horrible things are going to happen. Quite frankly, it doesn't happen that often. But if it does happen, there's nothing that sucks quite so bad as having mom die who had just paid for 25 years on a life insurance policy, and then that life insurance policy gets sucked away by a bankruptcy trustee, So instead of going to the kid, right? So we've had cases where that's happened. So that's a huge bummer. So anyway, so let's jump over to, which is kind of the central part of this, is talking about trusts. A trust is our third option, okay? The easiest way to think about a trust is like a box. So you set it up, you put your stuff into it. Throw your house in, your bank accounts, you put your life insurance, your 401k at it. Everything goes into the box. The box holds the stuff, you own the box. So it's kind of a one-step removal of ownership. And the reason that that's useful is that when you're gone, the box continues to exist. And you can designate people who step up, take control of the box and everything in it, and then follow your instructions. Whether it's to take the stuff out of the box and give it to the people who are supposed to get it, or or keep it in the box for the benefit of those people. You know, we were talking about a minute ago, what happens if you have a beneficiary who's 10 years old? You know, if we're going through probate, not only is that person an immediate beneficiary of that stuff, but now because that person's a minor, they don't even have the ability to receive it, which means that some other adult is going to have to start a conservatorship or a guardianship for the estate of that minor. So now you've got a probate, and then you've got a guardianship, which is like filing a probate every year for the estate of a minor. Okay, so with a trust, you can avoid all that. You know, the stuff can stay in the trust for the benefit of that person until the right time comes. Again, you can put conditions. You know, it doesn't have to be 18. It could be 25. It could be after they graduate from college. It could be, you know, after they hit some other milestone. You know, whatever you decide, you can put those kinds of conditions into it, and those will generally be honored, so you don't have to make an outright distribution. Or you could say, you know what, you get 10% a year for the next 10 years. You know, maybe I don't want to dump a bunch of money into the lap of like my 25-year-old kid. Sorry. And, you know, so, but by doing something like that, you can space it out over time, if that's going to be attractive.
So you have a will that gives instructions. Does the will go into the trust
Okay,
with the
so
instructions?
we're talking about mechanism. The trust is the hub. The trust has the instructions on where things are going to go. So we always draft a will to go along with the trust. But the reason we do that doesn't have to do with where we want the stuff to eventually go.
You can have him come or go to a call here in California.
Yes. Like one of the things you had alluded to a minute ago is trust funding. Remember, the trust is a box. All too often, what we see is that people set up a trust, maybe they throw their house into it, they go on with their life. And then 10 years from now, they sell that house and it goes out of the trust and they buy a new house. And at the closing, what do? They just put it in their names as joint tenants. And then they go on with their life and they both die. And now what you have is an empty box, okay? They didn't put the house in the trust. They didn't put their bank accounts in the trust. And so when they pass away, what they've got is an empty box. And that's a bummer because the trust can't control the distribution of assets that aren't titled or held in the name of the trust, okay? And so that's where the will comes in. Anytime we draft a trust, we always draft a specialized kind of will called a pour-over will. Maybe that's a term you've heard before. But the basic idea, a will is a letter of instructions to the probate court. This will says one thing, which is, dear probate court, if I have any assets that didn't make it into my trust by the time I died, take those assets, pour them over into the trust. So it's a post-death trust funding tool. Hopefully we never have to use it because guess where we have to go to do that? Probate court. But if we need it and we don't have one, we've got a big problem because there's not really any way to get stuff into a trust after a person passes away. So we always draft pour-over wills anytime a person passes away. But the hope is we don't use them. Okay? So that's what a pour-over will is for. So there is a will in the mix, but its only job is to serve as a post-death trust funding tool. Okay, so the trust becomes the hub of the estate plan. The goal is that everything goes into the trust controls where it's supposed to go, all the instructions related to what's happening are going to be in the trust. Now the easiest way to think about trusts is that trusts typically move in phases. Let's say we're talking about a married couple, okay? And let's not like we'll talk about blended families in a second, but let's not mix that up. Let's say that it's like, classic 1950s family. If you got mom and dad, you got 2.5 kids, and all the kids belong to both the parents, and there you are. Okay. So the way the trust works is trusts have three jobs. We have settlers, trustees, and beneficiaries. Settlers set it up and fund it. They're considered the owners of the property in the trust. Trustees manage it. And then beneficiaries are entitled to the benefits of the stuff in the trust. Now, typically, when we set up a trust for somebody, that person serves in all three of those roles. So they set it up, and then they manage it for themselves, during that person's lifetime. But then in the documents, we draft what are called successor trustees, remainder beneficiaries. So successor trustees are like the executors of the trust. The remainder beneficiaries are like the heirs. They're the people who are entitled to the benefits of whatever's in the trust after the settlers are gone. Okay, so trusts move in phases. If you've got a married couple, first phase is while they're both alive. Second phase is after one of them's gone. Third phase is after they're both gone. Okay, and so there are different rules about how things are typically going to work in a trust during those phases. Most commonly, the first phase, both spouses are the sole trustees and the sole beneficiaries. They can do with the stuff whatever they want. They can continue to buy and sell and make gifts and loans and refinance and do whatever else they want with their property. After one of them's gone, sometimes we put in restrictions. Okay, Sometimes we set it up, like one of the things we have in here is talking about Aable trusts. There are times where trusts are designed to subdivide into 2 trusts at the first death. The most common time we see that is with like a blended family, where you say to yourself, okay, you know, I've got kids, my spouse has kids, they're not the same kids. You know, we're a blended family. And after I'm gone, I want my spouse to be able to use my stuff, you know, with maybe some restrictions on it. But I don't want my spouse to be able to disinherit my kids. I don't want my spouse to be able to get all the stuff and give it to a new spouse if she gets remarried, right? So with an Aable trust, one of the things you can do is you can say, we're going to subdivide it into 2 trusts. We're going to put my stuff in one side. We're going to put your stuff in the other side. My side is going to become irrevocable. We're going to make it so that the terms of that trust are locked. We're going to put some restrictions on what the surviving spouse can do with it. We're going to make it so that she can't disinherit my kids or do anything else like that. And then after we're both gone, of course, then my stuff goes over here, maybe her stuff goes over here. Maybe we have a couple of joint assets that are split 50-50, but there's some things that can happen at that time to make it so that if I'm the first one to go, that my interest can be protected to a certain degree, okay? But sometimes we don't see that. Sometimes we have situations where people are like, okay, if I'm the first one to go, everything goes to my surviving spouse, and she can do with it whatever she wants. If she decides she wants to leave it to her new boyfriend, all the more power to her, but, you know, it just depends, you know, so yeah.
Do people really leave their pet as a beneficiary? So like, how do you handle that?
Oh, heck yeah, yeah. No, there are times. You know, of course, our office is up in El Dorado Hills, you know, and you guys are kind of moving, you know, up here, kind of starting to move towards the rural area. Sometimes we're not talking about dogs and cats. Sometimes we're talking about horses, you know, livestock, right? But I mean, the weirdest thing that I ever did is probably about 15 years ago, I drafted a trust for a couple, and they had grown kids who were adults. But they said, you know what? After we're gone, both of these people were veterinarians. And they said, after we're gone, our animals get to live in our house for the rest of their natural lifetimes. And all the funds in the trust are going to be used for their upkeep and maintenance. And then after they all die, then the kids can have what's left. So they're both still alive, so I don't know if they're going to change that. Yeah.
And then they designate a person to actually.
Yeah, and the trustee was responsible for carrying that out, the successor trustee. That's that person's job. They picked somebody specifically because they felt like that person would be a good person to take care of the animals. And they're like, the kids are fine. They'll do whatever, you know.
How many pets were there?
Oh, we're like 20. Yeah, we're talking like, yeah, like crazy cat lady and crazy cat. So at the end of the day, do you really want that house? I'm not sure.
Right. So what keeps the executor doing what they're supposed to do?
Okay.
What if they go rogue?
All right. Magic word that you guys have probably all heard if you're in real estate, which is the fiduciary duty. Okay. A fiduciary duty is a duty of loyalty. It's a duty to do what's in the interest of the beneficiaries and to follow the instructions that are in the document. So that's the key thing that's supposed to keep our trustees on the straight and narrow, okay? Because if they don't do that, then that's a breach of their fiduciary duty. And lots of bad things can happen. They can be sued. They can be surcharged. You know, all kinds of things can happen. In the law, if a trustee breaches that fiduciary duty and it winds up financially harming one of the beneficiaries, they can be responsible for up to triple penalties for that. You know, like let's say they misappropriated assets. Let's say they just stole from the trust, or let's say that they divided assets like it was supposed to go in thirds to these kids, and they gave most of it to these 2 kids, and this kid kind of didn't get what he or she was supposed to get. They can sue them for the difference and triple penalties. So now, having said that, of course, like anything in the law, somebody's got to step up and do it. You know, there are times where we've seen situations where people have done things that are dishonest, or people have done other things, and the rest of the kids are like, I can't sue you. I can't. I'm just not going to do it. And you know, but that's our backstop. That's what's there. Is the fiduciary duty. Trustees are definitely fiduciaries. You know, they're supposed to do what it says. Yeah.
So say you have 2 seniors,
Okay.
right? Is an Aable trust the way to prevent this person that has dementia now from this person losing everything?
So we're talking about like if the person needs to go into a nursing home or other things like that?
Or
Okay.
assisted living, or?
So how many hours do we have?
This is a I mean, such a commonality now, and I think for the next, you know, perpetuity, let's say. I see this more often than not.
Oh, for sure. Yeah. I mean, dealing with incapacity is a huge part of what we deal with. okay? Now, of course, the first thing, which we'll talk about in a couple of minutes, is powers of attorney. Every person ought to have a power of attorney because, of course, if you don't have a power of attorney and you become incapacitated, then a really bad thing happens, which is that somebody needs to get what's called a conservatorship. In much the same way that trusts are designed to avoid probate, powers of attorney are designed to avoid conservatorships. And a conservatorship is like going through probate every single year, because basically what happens is the court appoints a person to take care of an incapacitated person. And they have to report to the court on everything that they do, and there are all kinds of restrictions on what that person can do, and so that gets messy really fast. With a power of attorney, you can avoid all of that. But we'll talk about that in just a second.
Which is wrapped up in a good trust, right? Like
Yes.
that's part of.
The
Now,
trust.
Mhm.
can you do that in a will? Like, is that where the trust is a more beneficial approach versus just a will, where you can detail out all of, not only the financial and the asset side, but
Mhm.
the power of attorney and medical directives, that
Mhm.
kind of thing?
Yeah, so powers of attorney are actually totally separate documents.
Yeah.
You've got the trust, you've got the will, you've got powers of attorney. So you can have powers of attorney and not have a trust. In fact, one of my soapbox items every spring is I'll talk to clients and they'll say, you know what, our kid's graduating from high school, he's headed off to college this fall, it's gonna be great. And we're like, does that kid have powers of attorney yet? Is he 18? And if the answer is no, that's always my thing, is every person over the age of 18 ought to have powers of attorney.
Where do you get that? Like,
Oh, we draft it.
your-
Yeah, we can do it. To be
Oh,
honest, if you
okay.
want to just get a super generic one, you can download it off the internet
Oh,
and just write in some names and get it signed and notarized and off you go.
and that's it.
Well,
But-
there's power of attorney and power of durable health.
Okay, so let's talk about powers of attorney first. A power of attorney is a document that lets you designate some other person to step into your shoes and act on your behalf if you become incapacitated. Okay? They come in two big flavors: powers of attorney for financial, powers of attorney for healthcare. Now, within that, some of them are durable, some of them are limited purpose, some of them are general, some of them expire after a while. A durable power of attorney, which is what we usually like to draft, is a document that's designed to last for an indefinite period of time, which means either until the person revokes it, because it's a revocable document, or until that person passes away. So if you set up a power of attorney and you never change it, it's designed to go with you for the rest of your life. Now, obviously, if you're an 18-year-old, you're probably going to nominate mom and dad. You may not want that forever, right? So they are amendable documents. You can always change it. Like if you get married or if you have a significant other and you want to put that person on as your new agent under your power of attorney, you definitely do that. But with powers of attorney, what that allows you to do on the financial side is you've got somebody who can pay your bills, take care of your taxes, carry on litigation if you get in a car crash and it's the other guy's fault. Basically make sure your life doesn't fall to financial ruin. If you're in a car crash and you wind up in the hospital for 6 months. On the healthcare side, it makes it so that you've got somebody who can take care of you personally. Check you into a hospital, find you a new doctor, send for an operation, move you into a facility if you become incapacitated. Take care of all that kind of stuff. Now, within a well-crafted power of attorney for healthcare, we also like to see what are called advanced healthcare directives. Okay? Some states call it a living will. That's where you can indicate what some of your choices are on major healthcare decisions, just in case you can't communicate them at the time the choice is necessary. We talk about big stuff, like what happens if you're in a persistent vegetative state. Do you want them to pull the plug? Do you want to get alive? What do you want to happen? We talk about things like whether you want to be cremated or have your ashes scattered somewhere, be buried in a certain place, whether you want to donate organs, whether you have religious restrictions on the kind of healthcare you want to receive. In a good document, there'll be places to indicate your choices on those things so that the person you designate doesn't have to guess. Okay? So your wishes can be carried out. So those are super important documents. Everybody over the age of 18, even if you don't have 2 dimes to rub together, should have powers of attorney. Because you don't want to wind up in a conservatorship. One of the things that I always tell clients is you say to yourself, okay, your kid's headed off to college this fall. If your kid goes out and gets in a car crash and winds up in the hospital, nobody's going to call you. And the reason for that is it might be your kid, but he's not a kid anymore. As soon as you turn 18, you're an adult. And sometimes we deal with people who have kids with special needs, who are very developmentally disabled. And it's often shocking to them to discover that the moment that kid turns 18, the doctors won't talk to him anymore. Even though that person has been caring for this child's needs that person's whole life, and they've been taking them to the doctor and consenting for their stuff and everything else, as soon as they become a legal adult, all of a sudden the doctors aren't allowed to talk to them anymore unless and until they get a conservatorship. So it's definitely something you don't want to have happen. So that's always something to think about, like when you're just looking at kind of your checklist of things that you do as a grown-up. One of the things you ought to consider is having powers of attorney, both for financial and for healthcare, just to make sure that you've got the tools in place that you might need to take care of those kinds of things. And that's something that we typically do when we put together an estate plan. We almost always do a trust. I always tell clients, if you have a house, you want to have a trust, because the house by itself will throw you into probate in California, unless it's worth $62,000 or less. Good luck. But then we draft wills to serve as a backup to the trust. We draft powers of attorney for financial and for healthcare. We draft what's called a trust abstract. Now, a trust abstract is a short form summary of the key provisions of the trust. And the reason we like to use those is because, maybe you guys, especially like the title folks, probably see these a lot. A trust abstract basically gives, it's for trust funding, it's basically to take care of transactions. Because of course, the client's first job, once the trust is completed, is to zip over to the bank, talk to the financial folks, get the accounts put into the trust, put the stuff into the box, right? And as part of that, typically the bank's going to want to see a copy of the trust. Sometimes there's stuff in the trust that's in the bank's business, like maybe who the beneficiaries are, or where it's going, or the terms under which it might be going, or whether somebody's getting disinherited, those kinds of things. So for the trust abstract, it gives them all the information they need to know, leaves out all the stuff that's none of their business. We sign it and we notarize it just like a trust. So it's like having a mini trust that you can use with the rest of the world. So it's the primary trust funding tool. So we always draft those. And then of course we draft deeds on the real estate and get that recorded with the county, to take the house out of the people's names as individuals, put it into the name of the trust with the two of them as trustees. I always say, we're taking off our owner hat, we're putting on our trustee hat, okay? So.
Do you have to do that?
Well, unless you want the house to go through probate. Yeah.
So yes.
Yes, the short answer is yes. Yeah, if you want it to be a trust asset, it needs to be funded into the name of the trust. Now, a couple of important things on that, and this kind of gets back to what we're talking about with taxes and other things like that. What we're talking about is what's called a revocable trust, okay? Now, the key thing about a revocable trust, of course, is you can revoke it, which means you can also amend it. You don't have to, it's not locked. You can change the rules. You can change the beneficiaries, percentages, specific gifts, anything. But the other thing that's important about a revocable trust is that a revocable trust is transparent for tax purposes, okay? So you don't have to file a separate tax return for the trust. Taxpayer ID number is still just the person's social security number. Putting a house into a revocable trust is not considered a true change of ownership, okay? And the reason that's useful, as I'm sure you guys probably know, is, first of all, it doesn't blow a mortgage. It's not a change of ownership. It doesn't trigger a due on sale clause, okay? Secondly, it doesn't lead to a reassessment for property tax purposes, which for a lot of people in California is super important, right? If you've had a house for 25 years, you go to throw it in a trust, and they're like, we're going to reassess the house. You're like, right? So yeah, so there's specific designations in the Revenue and Taxation Code carving out an exception for transfers into a revocable trust, okay? So it's not considered change of ownership, it's not gonna blow your mortgage, it's not gonna lead to a reassessment, okay? But anyway, when we're talking about irrevocable trusts, so an irrevocable trust is kind of the opposite. First of all, once you set it up, you're not supposed to change it. You're not supposed to change the beneficiaries, you're not supposed to change the trustees, you're not supposed to change the distribution rules. Essentially what's happening is every trust has those same three jobs, settlers, trustees, and beneficiaries, but in an irrevocable trust, the settler's job is basically done once the trust is created and funded. You throw the assets into the trust, and then you sort of hand it over to the trustee. Now, sometimes the trustee is also the settler, but the settler's ability to change that document is significantly restricted. And the other thing, of course, is that an irrevocable trust is its own free-floating entity. It does have its own taxpayer ID number. It does have to file its own tax return. Yeah.
What if you end up getting more assets and you've got the irrevocable? How can you get it in there?
Well, you can still put stuff in. It's still a box.
Okay, so at any time, if you get more,
theoretically,
you can put.
Yeah, you can definitely do that with a revocable trust. Sometimes there are rules in an irrevocable trust that will restrict that.
Right.
And there will often be rules about what can be pulled out of an irrevocable trust.
Can you give an example of why would you have one over the other?
Okay, so irrevocable trusts actually have have some very useful purposes. The classic trust fund baby trust is an irrevocable trust because the main reason that people do that stuff is for tax purposes. let's say that you've got a $100 million estate. You know that there's no way that you're ever going to be able to pass this stuff down to your kids without getting totally killed in estate taxes, okay? Right now, the estate tax exemption, the unified credit, the amount that a person is able to pass to any other person without having to worry about an estate tax is a little over $14 million, okay? So, and if you've got a married couple, they each get a unified credit. Each of us has a unified credit, okay? And you can use that during your lifetime, and whatever's left is gonna go to, it becomes part of the estate tax, okay? So, you can set up, let's say you say, I've got this huge estate. I know that there's no way I'm ever going to escape the estate tax at the end of my lifetime. I've got 3 kids. I'm going to set up an irrevocable trust in the name of each of these kids, and every year I'm going to throw money into it. I'm going to make a gift into that. Because on top of your unified credit, you also have what's called your annual exclusion. That's the amount that you can give away to any person every year without even touching your unified credit. Right now, it's about $18,000. Okay, which again, when you're talking about $100 million
Is that
estate.
the gift tax?
That's without a gift tax. Yeah, you can give away like
Per parent.
and per recipient.
Right.
Yeah. So you could give away. So like mom and dad could give $36,000 to each of their 3 kids every year, but they don't just give it to them because maybe the kids are 2 years old. Maybe what you do is you throw it into this irrevocable trust. As long as it's under the annual exclusion, you don't even have to file a gift tax return, and you do this year after year after year, and of course that money is invested, so hopefully it continues to grow in value. But by doing that, what that allows you to do is, I mean, the easiest number to think of is every dollar you can get out of your potentially estate taxable estate is about 50 cents saved. Okay? The estate tax is not great. So now having said that, of course, at $14 million per person, the number of estates that have a potential estate tax due, I mean, the number that I read was 99.997% of estates don't have an estate tax. Hardly anybody has an estate tax, or an estate that value. But if we've been doing the same conversation back in, say, 2001, does anybody know what the estate tax exemption was back then?
$7.5 million.
Exempt.
$1 million. Yeah.
Whoa.
It started to crawl up, and then they sunset it back, but then they continued to index, and it keeps going up. Now, back in the 90s, it was $675,000. You know, so tons and tons of people had estate tax problems, especially in California. Yeah, oh, and that's the other problem.
You don't know what it will be when you need it.
In 2026, it's supposed to sunset back to like $7 million. So now we're only talking about 99.97% of estates, but still, you know, it's a problem. But of course, back in the day, tons of people had estate tax problems. That was the other time when we saw lots and lots of Aable trusts. The main reason you would use an Aable trust was not to protect your estate from the kids of your spouse. It was to make sure you could hang on to both estate tax exemptions. You know, because typically you have 9 months to file your estate tax return, and if you don't do it within that period of time, then it goes away. And so what you do is you'd split the estate into 2 pieces, throw half over here, half over here. You'd apply each estate tax exemption to that particular trust, and by doing that, you could double the amount of money you could pass estate tax free. We have much more elegant ways of handling that now, but that was actually where the Aable trust was first used, was for estate tax avoidance. Okay, so.
I think the irrevocable, you have to be careful, because once you put it in the box, there is no going out and getting mortgages again.
Oh yeah, for sure.
And you're basically not able to leverage that asset anymore, because you can't say it's for, you know, backstopping something, because once it's there, it's there. It's not yours anymore.
It's not yours anymore. That's the key thing, is as soon as you put something into an irrevocable trust, it's not yours. You might be the trustee, you might be able to control it, but you have to control it according to those rules. And like you're saying, there are a lot of banks that aren't going to loan.
And make sure that you've got your distribution set up within it. I have a gal that had 2 properties in San Francisco, a couple $100,000 on a mortgage on each. She's still liable for both, but she pretty much put it in irrevocable because it was a better tax scenario to give to her kids. So it's sitting there, and they're living in the properties, but she can't do anything with the mortgages. And it's on her debt. Luckily, after a year of showing that the trust is paying the mortgage, she no longer has it as her personal debt anymore. But it took her a year for the trust to pay before.
Well, it's kind of interesting that you mentioned the tax advantage of that, because one of the other big problems with an irrevocable trust is because you are no longer tied to that asset. What happens when you die? When you die, okay, so let's talk taxes again. Remember, we had property tax we already talked about. Now we're talking capital gains tax. How many of you guys have heard of the term basis? Okay. Basis is what you pay for a piece of property. So let's say we got a piece of property in San Francisco. Mom bought it for $80,000 back in 1961, okay? And she's held it this whole time, and she keeps it until she dies. And now it's worth $3.5 million, okay? So her basis was whatever that first number was, okay? And so just to talk general principles, let's say you buy a piece of property for $100. That's your basis in the property, okay? If you were to turn around and sell that property for $100, you don't have to pay any taxes because you didn't make any money, right? But let's say it goes up in value to $200. Now you've got $100 of basis. You've got $100 of what we call gain. Gain is what you potentially pay taxes on. Capital gain, ordinary gain. You know, gain is what you increase in value, right? Now, when a person passes away, that person's estate is entitled to what's called a step up in basis, okay? Which means that the basis is stepped up from whatever it was back in the day to its full fair market value as of the date of death, okay? And that's a super, super important thing, because what happens then is when it gets passed on to the person who receives it, they receive it with that stepped up basis, which means that if the kids say, here's this $3 million property in San Francisco, I don't want it, I'm gonna sell it. They can sell it, and because they've got the stepped up basis, they're not gonna have to pay any capital gains tax on that. So that's huge. And that is one of the reasons why, nobody's mentioned it so far, but this is one of the reasons why, first of all, it's almost always a terrible idea to transfer your house to your kids while you're still alive. And it's why it's almost always a terrible idea to put your kid's name on your property before you die. Yeah, on title. Because one of the things that people will say is they say, trusts seem like a giant pain in the butt. What if I just put my kid's name on the title as joint tenants? Then when I pass away, right of survivorship, it goes to the kids. That's great. Okay, the big problem is you've just given away, if you have two kids, you've just given away 2/3 of your house to your kids. And secondly, what that means is when you die, you're only getting a 1/3 step up in basis. Your kids didn't die.
And they're gonna have a property reassessment as well.
Yes, they certainly are now. So, yeah.
And forgive me if you already said this, is there a max, is it a $1 million cap on that step up, like property that maybe were now valued above $1 million?
No. You could have a property that's worth $100 million and it still gets a stepped up basis. Yeah. So
that's significant.
It's huge. It's super huge.
Yeah.
Okay.
We see it all the time in the title side. I'll get calls weekly from an older person saying, oh, where do I go get a deed done? Because I want to put my child on my property. And we're not allowed to give legal advice, but I tell them you really need to talk to a CPA or an attorney before you go do that, because they just think it's the natural thing to do. They want to make sure their child gets the property without going to probate. They're scared of everything.
Yeah.
And then you've got the other side where you've got kids telling their parents, oh, you need to put me on title. And the kids don't even realize that when the parent dies, they're going to inherit 100% at that cost and sell it tax free. So it's, the trust is really the only way to.
Gains taxes. So, yeah, and then you had a question.
I want to go back to my original question about, say.
Did I skip your original question?
Well, so you have a couple. I want to know if I use a trust and my husband gets dementia, I want to be able to keep my house, keep living in it.
Okay.
And what happens, can you either take a revocable, make it irrevocable, or use an AB part revocable, part irrevocable?
Even better than that, you don't have to do anything. So, we're talking about Medi-Cal.
Yes.
Medi-Cal is a federally funded, state-administered program, and one of the programs that they have is what's called the long-term care program, okay? Now, it used to be that in order to qualify for Medi-Cal, the person in care couldn't have more than $2,000 of countable assets, okay? That's terrible, okay? A few years ago, they bumped
total
that.
assets?
Well, the house was not a countable asset while the person was alive, but it was a recoverable asset after the person died.
Right, so you could lose the house.
So you could lose the house. They could come back and say, oh, here's your bill for $400,000.
Right.
Okay, here we are in 2024, and for once, I get to be the bearer of good news. Good news is, they did two things. Back in 2017, they made it so that any assets that were held in a non-probatable situation, so the match word is revocable trust, would not be available for recovery by Medi-Cal. So if you have your house in a trust, they can't touch it. It used to be, before 2017, that we had to do all kinds of tap dancing. We had to set up all these complicated irrevocable trusts. We put the house into it. We'd set up what's called an intentionally defective grantor trust, where we were able to get the stepped up basis, but we were still outside for Medi-Cal recovery purposes. We had to set up what are called special needs trusts to hold all the cash and then transfer the assets out in this really clunky way to make sure that we didn't incur a huge look back period, okay? Well, as of January 1st of this year, Medi-Cal has said, we don't care how many assets you have. That's not going to be a countable part of the Medi-Cal application anymore. And the 2017 rules are still in effect. So if you take your stuff and you put it into a revocable trust, and then one of the spouses becomes incapacitated and needs to go into a nursing home, it has to be a skilled nursing facility, that's an important thing, then first of all, they're not even going to ask what your assets are. They don't care, which is mind-boggling to me, okay?
But based on income then?
But then, yeah, but then they can still give you a big share of cost depending on your income. So, and so sometimes.
It's income-based, not
Yeah.
asset-based.
Well, there are two things. It was always income and asset-based. If you have too much stuff, you're just not going to qualify. If you have too much income,
Right.
then what happens is there's a thing called your share of cost, which is basically your deductible.
Yeah.
You know, and if you had too much income, then your share of cost was so high that you're like, what's the point? Let's pay for it out of cash. So,
Yeah.
So they haven't really changed that.
Okay.
But they changed protections in that, where they're not gonna come back
Right.
and take your assets.
Yeah, against
Depending on how
Medi-Cal
much
recovery is what it's
interest.
called. So they've kind of done away with most of that.
And assets including 401ks, all of the bank account stuff?
Yeah,
too?
see, the
Okay.
big problem with 401ks and IRAs is, especially once you hit a certain age, you have to take your required minimum distributions. There's not really any way to get around that, you know, and that will be countable as income, which is going to increase
Okay,
your
I
share
get
of
it.
cost.
Okay.
Things like Social Security or
Right.
pensions, other things like that are almost always going to be share of cost. Now, sometimes you have a person who's like, you know what, I just got this big brokerage account and it kicks out $200,000 every year, and that's what I live on. That's great. Or maybe they say, I've got a portfolio of rental properties and that kicks out income every year, and that's great. Problem is that's all income. So what you need to do, if you have stuff like that, is that might be an opportunity to throw stuff into a specially crafted irrevocable trust, have the income go to the trust instead of to you. Now, all of a sudden, that's not countable income, which means you can significantly reduce your share of cost. So there are tools. There are tools that we can use to do stuff like that. But for a lot of people, if basically they're living off their 401k, or maybe they have a pension, or maybe they have Social Security, that's going to be the sticking point. The bottleneck is going to be the income, not the assets.
When you say skilled nursing
Mm-hmm.
home, is that also assisted living? Right,
Not
so
right
that's different, that's
Yeah.
the step up
That's
after
kind of the
assisted living.
donut hole of this problem.
Right.
Is you have to qualify for what's called a skilled nursing facility. And a continuum of care, you know, there's what we think of as boarding care, then there's residential care facilities for the elderly, then there's skilled nursing. Okay? Skilled nursing is like if you have dementia, or if you need, if you need help with what's called the activities of daily
Daily
living.
living.
Yeah, if you need too much of that kind of stuff, they'll bump you up the continuum of care until you wind up in a skilled nursing facility. But quite frankly, we've had lots of situations where clients were like, you know what, mom's kind of on the bubble. You know, maybe she could be in a nursing home, maybe she doesn't need to. But if she's in she's in a skilled nursing facility, she can qualify for these things. So they'll kind of push to have the person moved up the continuum of care, so they'll qualify for programs like that.
So a skilled nursing, that's way up there. I'm still talking about assisted living then.
Okay.
So now,
Well, if
Can
you're on
they
assisted
take-
living, there's not a Medi-Cal program for you.
right, so
Yeah.
now now you want to protect your home
Okay.
from this person in assisted living taking all of, having to sell the home to pay for that, or
Mhm.
can you keep that home is there a way to do that?
I mean, there are things you can do. I mean, like, if the person like has dementia and doesn't really have the ability to like transfer assets anymore, that becomes very difficult, because then it starts to look like you're robbing your spouse, which is a breach of your fiduciary duty, you know? But I mean, the biggest problem, that's why I call it kind of a donut hole, is you just drop right through the middle of that. You know, if you've got a person who's just in a residential care facility for the elderly, Medi-Cal doesn't have a good program for that. And, a lot of times that means that people are gonna wind up paying for that out of pocket.
So there's no way to protect your house. You'd have to sell your house to make payments or to be able to pay for that.
I mean, a lot of it just depends. I mean, because the other thing to keep in mind is, depending on where you go, like a board and care facility or a residential care facility for the elderly, where they're not like doing the higher level stuff, you can probably have a person in something like that for $4,000 to $5,000 a month. So it's not like crazy, crazy expensive like nursing care. And so, I mean, sometimes that is affordable for some people. Sometimes it's not.
For a period of time.
For a period of time.
Yeah, I think it all comes down to cash flow at that point of what you can handle.
Mhm.
And then at some point, you're probably not gonna handle it.
People
and
can
you're
live
either
for
gonna
20
look
years
at-
there,
You're gonna look
Yeah.
at reverse mortgage or pulling out equity.
Yeah,
or
right.
something
There are
like
tools
that.
that are available, but there's not a great tool just in the trust world
Okay.
to
that's what
move
I meant.
assets. I mean, sure, we could get rid of the assets and make it so that you can go and just like talk to the facility and say, we don't have any assets, what are we gonna do? But the difficulty, of course, is in most of those kinds of things. If you're talking about a private pay situation, private pay bed, then they're gonna find your stuff.
Thank you.
It's a challenge.
So theoretically, if you put your income in, your residential income, investment income into an irrevocable trust, you could have, under the guidelines of the trust, a distribution would say spin out 5,000 and then you pay 5,000 on tax on that income instead of 20, right? So it's a way for you to maneuver your taxable ability.
Not really, because the problem with an irrevocable trust, of course, is the irrevocable trust has to pay its taxes. So, yeah, even if you don't distribute any money to the beneficiaries, if there's income coming into that trust, the trust has to file a tax return, and irrevocable trusts actually pay taxes at a much higher rate than.
Okay, so it's best just to have it as a holding box until everybody dies and then it gets distributed to the
Yeah,
beneficiaries.
if it's not kicking out income, then that's not gonna hurt. But I mean, the important thing about irrevocable trust, because a lot of people are like, well, why shouldn't I set up an irrevocable trust? There's a carrying cost that comes with that. The number one is, like when we look at our tax brackets, like when you and I pay taxes, as we go along and our income goes up, we go up to another tax bracket, it goes up. With irrevocable trusts, it goes like this. When you get to about $14,000 of income in any given year, you're up in the top tax bracket. So it's almost like having a flat tax of the top tax bracket. And the reason they do that, of course, is because back in the day, the whole goal was people would set up what they considered dynasty trust. They'd set up an irrevocable trust and just say, all the income is going to get kicked out to the beneficiaries forever and ever. It's just going to, never going to pull the assets out, and that's how it's going to work. And so they said, well, if we do that, then if you've got $15 million sitting in here, we're never going to get our estate tax on the transfer between parent and child or whoever's supposed to get it, right? So they said, we're going to make the taxes so onerous here that they kind of give with one hand and take with the other. Now that's not such a problem, because if you've got a $14 million estate tax, you can pass a lot of money down to your kids before you have to start worrying about that. So, yeah.
My father-in-law has an irrevocable trust, my husband's the trustee for.
Okay.
And it can't have any taxes. So we have to take the profit every year and distribute the profit. It
Okay.
cannot gain any income. You can't keep putting money back into this irrevocable trust.
Okay.
So every year we take out, it makes about 30 grand, I guess.
Mhm.
And then it goes to my husband and we pay taxes on that.
Okay. Yeah, I mean, you could structure it that way. The challenge, of course, is sometimes you just can't do that. Sometimes the beneficiaries are 10 years old, or sometimes the beneficiaries are disabled, and like it would.
I don't know why they did it that way,
Yeah.
frankly. Why
Well,
didn't
it's
just
almost
go-
certainly because of the tax differential. And the trust
Yeah.
would have paid probably
So
30%
we
more
pay less
taxes.
taxes as an individual than the trust would pay?
Yeah.
Oh, I see,
So,
okay.
yeah.
Thank
And
you.
whoever created the instructions for the trust set it up that way to ensure it was the cheapest methodology
Okay,
for
thank
withdrawing
you.
the money.
Yeah.
I always
Right.
wondered
So
about
that's
that.
probably what the goal
Like
is.
setting
on something like
whoever was the beneficiary up for success, basically,
Mhm.
right?
that. Yeah, the hope. So,
Thank you.
okay. So, let's see. So we talked about a couple of other things about non-probate transfers. So one of the things that you guys probably see all the time is joint tenancy. Joint tenancy with the right of survivorship. So when we look at other tools, that's one of the most popular ones. You say probably 85% of the deeds that we see coming in with somebody who's going to set up a trust, if it's a married couple, they just don't use joint tenants. And of course, the hallmark of joint tenancy is the right of survivorship, what we always call the last man standing rule. Like if the three of us bought a property together and we all bought it as joint tenants, and then I went out and got struck by lightning and I was gone, by law, it passes to the two of you, and now you're the 50% ownership. And if you get eaten by an alligator and you're gone, you're the last man standing, which means it now belongs to you. And on real estate, all you got to do is file what's called an affidavit of death. It says, hey, remember how Dave used to be a 1/3 owner of this property? Here's his death certificate. He's not here anymore. Now it belongs to the two of us. After you're gone, they do the same thing that goes to you. Of course, the big problem is what happens when you die? Now we don't have any joint tenants left, right? Which means that it's part of your probatable estate. So, so that's, that will avoid probate, but you're just kind of kicking the can down the road as far as those things go. Unless you're like the situation we were talking about with clients where they say, I'll just put my kids on as joint tenants. And then you've got the problems we talked about with the taxes, with the only partial stepped up basis, the gifting, because like if I had the property and I put you guys on as joint tenants, that's a gift from me to you of a 1/3 ownership interest in that property each. I might have to file a gift tax return on that. But the other problem is, if you take and you put your kids on your house, okay, you put them on as joint tenants, not only is that a gift of part of the property, but they're also an immediate owner with you of that property, okay? What happens when that kid gets a divorce? What happens when that kid gets in a car crash and gets sued? Again, we're starting to talk about all that liability stuff. Now, mom's house is a potentially available asset in that lawsuit. We've seen this happen.
I just want to say, I think that just in my experience on the real estate side of this, it's the what if scenario that that causes most of us to avoid taking the step of the work involved in will and trust and estate planning, let's say. But I can tell you with certainty every year, 15, 20 people had that what if scenario happen where, I made my kids a part owner, but 10 years after I made that decision, now my kids are getting a divorce and it's nasty.
Yeah.
And I'm involved in this huge scenario. And so I guess from my perspective, I just wanted to share that, like, it's always a what if scenario until it actually happens.
Yeah, for sure.
And it's just, I've seen it happen so much, unfortunately, and it's not like you tragically die instantly. It's just that weird kind of scenario where you didn't expect your kids to get a divorce and now you're wrapped up in this divorce. And so I think everyone who owns something should really look at this hard, because it just forces you to focus on it for a 2-3 month period while you get it set up. And you can set up those things like the will, right? It's all kind of wrapped up in one. It's not just the trust. You're kind of taking care of all those things at once, and you're really thinking outside the box of, like, your form was great. It asked, honestly, I had to really think about, well, what do I want to have happen if I can't make a medical decision, right? Or if I'm on life support. And I told, my wife and I had to talk about that, right? It was kind of hard. She would want it to keep going. I would want her to pull the plug. I'm not gonna sit there like a vegetable, right? And so I think, that's just an important thing to really honestly think about when you're looking at this is, I know it sounds kind of wonky, oh, my kids won't get divorced, or oh, my kids won't fight. I promise you, when you're gone or when it's chaotic, it happens to the people who thought it wouldn't happen. I mean, it's insane.
And I think the beneficiaries are basically off the hook after you put it in your trust on how you want things handled, because it pretty much gives them cover to do what you say to do, and it's off them. So it's going to keep the kids from fighting amongst themselves.
Sometimes, So, question?
Yeah, so this is off topic, but hopefully it is reviewing a trust I already have with somebody else to get a second opinion on it. Is that a service that you offer?
Oh, absolutely, yeah.
Okay.
We do free trust reviews.
Oh, you do?
Yeah,
Okay.
Costs.
How often do you have to do a review?
Okay.
Because I've heard different things from different people.
What I always tell clients is take a look at it every year or so. You don't necessarily have to do a review with me, but because key things, like in a trust, every trust has what's called a Schedule A. That's the list of assets and the classes of assets that are in the trust, okay? All the bank accounts, all the real estate, all the life insurance policies, all that stuff. If you change those things, you should update your Schedule A. Like if you open up some new bank accounts, or if you buy another piece of property, you should definitely keep that Schedule A up to date, because it does two things. First, it shows your intent that those assets be considered trust assets. And, because you can imagine a situation where you set up your trust, and like we were talking about, you throw your house into it, and then you sell that house and you buy a new house, and you forget to put it into the trust, and then you die, and now that house is technically a probate asset. A good, well-crafted Schedule A is another document that shows your intent that all of your real estate should have been trust assets. So we don't just say this particular address and this particular bank account. We say all of my real estate, including, and list out the ones, all of my bank accounts, all of my financial accounts, all of my insurance policy proceeds, all of my vehicles, including, But the other thing that it does is super important is it serves as a useful inventory. There's nothing worse. We get calls like this probably a couple of times a year from somebody who says, my mom died like 10 years ago. She had a trust, everything was super smooth, everything went great, we transferred everything. Just discovered that mom had 3 accounts that nobody knew about. They had like $400,000 in them. They got sucked away by the state of California. And we don't know what to do. So if you have a good up-to-date Schedule A, it's a good roadmap for your successor trustee, because there are lots of times. I mean, like just thinking for yourself, do you have any idea where your parents bank? Do you have any idea how many life insurance policies they have and other stuff like that? So, yeah.
Will your company serve as a trustee on a trust?
No. Not ever.
That sounds horrible.
But, yeah.
No,
That's a really great question. There are people who do that. But,
yeah, what was that? Who is that?
Okay, so the people who do that as a job, like some banks have trust departments, they will serve as that. But there are also people who do that as a job. We call those people private fiduciaries. And that's what they do. They will serve as the executor of your will. They will serve as a successor trustee on your trust. They will serve as an agent under
What's
your
it
power
called
of attorney.
again? I'm sorry.
A professional fiduciary or a private fiduciary. So the nice thing about a private fiduciary is this is a person who's licensed. It's a person who has a bond or some insurance. And it's also a person who does this as a job. Because there are lots of times where clients come in, they're like, you know what? None of my kids are like real financial all-stars, and I'd like to designate one of them as our successor trustee, but they would all do kind of a crappy job. So you can hire a private fiduciary. And the nice thing is, first of all, that person doesn't care if your kids are bad about what they're getting or not getting. They're going to do it right. They're going to give an accounting that would qualify under a probate. They're going to do all the stuff they're supposed to do. It's almost like you're hiring the bad guy, right? That way the kids aren't going to fight with each other. They can all be like, oh, private fiduciary, what a jerk, but the jerk doesn't care. They'll do the job, Now, of course, the major downside of that is they charge money to do that,
Right.
But there are times where clients say, I know whichever of my kids I pick, the other kids are just gonna tear that person to shreds.
So if you gave instructions inside your trust that you wanted the home to be sold upon your death and the proceeds split however, the trustee would be the one to do that?
That's correct.
Okay.
Yeah, that's that person's job. And it's, in particular, if you put in the rules that say they have to sell the house, you have to kind of be careful about that, to be honest, because that's what they have to do. And even if it's like a super down market, or even if one of the kids in the family was like, well, I always kind of hope that I could have the house, they have to buy out the other kids, So you have to be kind of careful on those rules. So, say that again.
Can you make co-trustees?
Okay, you can.
Sounds.
So
Is that a
co-trustees.
good idea?
Okay, we generally don't like to see co-trustees, and the main reason for that is much less of a legal issue and much more of a practical issue. There are a lot of banks, we've seen this many, many times, that don't like to work with co-trustees. And the main reason is because the bank doesn't want to wind up being liable if one of the co-trustees shows up and empties out the bank accounts, and the other trustee shows up a week later and goes, what the heck, bank? Where's all of our money? So there are a lot of banks out there where if you have co-successor trustees and they show up at the bank's just like, you gotta close these accounts and take your money and go somewhere else. Or they'll require them both to show up at every transaction. They'll require them both to sign every check or other things like that. So it just becomes a huge pain in the butt. So we generally like to see one at a time, but there are times, just like we were talking about a second ago, where a parent will say, you know what, I know whichever one I pick, the other one's gonna be mad. So I'm just gonna make them both trustees, sucks for them. They're just gonna have to do it, Yeah.
So
If they
those
may
bank
not
accounts that have beneficiaries, do
Mhm.
those also go into the trust? Or
Okay,
no?
so if we put them into the trust, we don't use our beneficiary designations. The beneficiary designation is the rules of the trust
Okay,
itself.
that's
Because
what-
remember,
Okay.
again, let's say that you had an account and you wanted to put it into the name of the trust, or in the trust itself, you said, this account ending with these numbers is going to this person, but you had a beneficiary designation on that was going somewhere else, that beneficiary designation is going to control. Make sure everything is lined up. So yeah, so in general, having a trust, if you take the assets and put it into the trust, then those beneficiary designations are moot. They get canceled. Okay? So that's super important. And the reason that that's also useful, because sometimes clients are like, that sounds like a giant pain in the butt, so I just like to keep my beneficiary designations. I have 9 checking accounts, and that sucks. So one benefit of having a trust that you definitely do not get with a beneficiary designation is in a trust, you can put in what are called spendthrift clause protections. Now remember how we were talking a minute ago about when mom dies, the only thing they can do is cut a check to the beneficiary? Well, if that account's held in the name of the trust, we always draft in provisions that basically say, okay, if we have a beneficiary with a problem, a beneficiary is going bankrupt, a beneficiary is getting divorced, a beneficiary is getting sued, a beneficiary is getting audited by the IRS, we can hang on to that beneficiary share and not make an outright distribution to that person unless and until the problem goes away. So
like the money can sit in the stock account
Yeah.
under,
it can sit in the trust.
okay,
And the nice thing is that
Okay.
that creditor floating around out there doesn't have the right to go through our beneficiary to the trust to demand distribution that they can then seize. So it protects your estate from the creditors of your beneficiaries. If
They
there are
wouldn't even have visibility to that
No,
asset.
yeah, they don't have to declare that it exists because they're technically not the owners of it until they actually receive it. So that's a very, very useful tool in the right situation.
So question regarding, say, a stretch IRA.
Okay,
That would be something that would not go in a trust because it's already got its tax efficiency built in, right?
okay, so stretch IRAs don't exist anymore.
Okay.
With the Secure Act, which was passed a few years ago, what happened is they made it so the only person who can receive an IRA without having a certain number of years to pull it out is a surviving spouse. A surviving spouse can do a full rollover and then continue those tax deferral benefits. But anybody else, if it's a surviving child, they have 10 years to pull it out, okay? And if they don't pull all that money out within 10 years, and it doesn't matter how old they are, they could be 25 years old, they've got 10 years to pull it out and take the tax hit on all those dollars. And if they don't, then in year 10, they treat it as if they pull it all out in year 10, and you get creeped in taxes, okay? So. Yeah.
What about limiting risks by putting all assets, houses, cars, things like that into the trust? Does
Okay.
that limit the beneficiary's risk from, say, lawsuits in the future? Is that like truly its own entity and asset, like those assets sitting in the trust are not at risk for litigation?
Okay, so a classical trust, a revocable trust, is not considered an asset protection tool in that way, okay? And the main reason is because it's the flip side of everything that we're talking about. You know, putting a house into a trust is not a change of ownership. It's transparent for tax purposes. Everything is still considered owned by that person. But the flip side of that, of course, is you don't get to throw all your stuff into a revocable trust and pretend like you don't have any stuff anymore, which is really what's happening when we're talking about asset protection. Is you're just like, sorry, I don't have any assets. I'm judgment proof. So when we're looking at that kind of stuff, a revocable trust is not the tool that we use. I mean, to be honest though, the very first piece of protection you ought to have is a good umbrella policy, a liability policy. You know, you can get like $1 million or $2 million of coverage for like $400 a year, you know, so that's always your first line of defense. And I mean, obviously I don't sell insurance, I'm not an insurance broker, but every single person ought to have an umbrella policy. You know, you can get one on your house, it's super cheap. That way, if you go out and get in a car crash and you hurt somebody beyond the limits of your auto policy, the umbrella policy will kick in and cover that. It also covers things like what happens if somebody slips on your sidewalk, what happens if somebody falls down the stairs, what happens if somebody gets hit by your dumb dog. You know, that kind of stuff is generally covered by an umbrella policy. So that's always your first line of defense. Now, sometimes we have clients who are like, well, I'm super risk averse. I've got lots of assets. You know, then there's structuring we can do. You know, we can throw things into a family LLC, we can throw things into family limited partnerships and all kinds of stuff that's really, really outside the scope of what we're talking about today. There are tools that are available to be able to do those kinds of things, and we do all those kinds of things as well. We do a lot of asset protection work for high net worth clients if it makes sense. But we don't want it to be the kind of thing, again, where the cure is worse than the disease. You don't want to set up this big, super complicated thing where you set up an entity and now you have to pay $800 in franchise tax fees every year to the state of California. You have to file a separate tax return, maybe you're getting premium and capital gains tax, all this other stuff, just for protection that you could have just spent like a couple $100 and gotten through insurance.
that umbrella policy is one of the best things you could ever buy.
Yeah.
We had an incident with a family friend where they're a hunting family and the son came home from lunch at Jesuit and he had left a loaded rifle on the wash machine after dove hunting. And he came home and he thought it was empty because it was drying out and it went off and shot the kid that was at the house right through the shoulder. And the parents, and it was a freak thing. And the family ended up having to, it was $1 million policy that the kid got paid out on 2 years later. But it had they had not had that policy and they put the policy on because they were getting a swimming pool installed. That's the only reason they bought that policy, because they were gonna have all these contractors coming in and out of the house. I highly recommend that.
Oh, yeah, for sure.
That's just,
And the cost is not
it was
much,
nothing.
because if you put your autos in there, it almost washes out as a couple
Oh, for sure.
$100.
Oh, yeah, you'll get like a
Because
multi-line
you
discount.
get, it lowers the auto.
It's amazing to me. And again, I don't sell insurance. I don't know how they get compensated, but it's amazing to me that that's not one of the first things that every insurance broker tries to
Pushes, yeah.
push with their clients. It's like
This is not
one of the
expensive.
most valuable like things you can do for your clients.
Yeah, like, I'm a Dave Ramsey guy, it's one of the first things he recommends doing, is, once you've kind of like, you own something, a house, cars, is like starting to set up ways to limit your risk of loss,
Yeah,
right?
for
'Cause
sure.
it doesn't take a lot to have an accident like that happen.
It's just like you said, you're not
So
prepared.
I think that's a misconception, I will say, of trusts in general, is people say they wanna, you probably get this a lot, I wanna
Oh,
set
yeah.
up an LLC and so I can hide all my money and,
Yeah.
I think the trust and tax question is very misrepresented. Like,
Yeah.
people think, I'm gonna set up a trust so I save money on taxes,
Yeah.
but the estate tax, as you said, is what, $14 million?
Hardly everybody has a state tax problem.
Yeah, very
Yeah.
few people ever get that,
Mhm.
so.
Well,
yeah,
I mean,
interesting.
yeah, so hardly anybody has an estate tax problem. Almost everybody has a probate problem.
Yeah.
I mean, so,
So how do you charge for your services?
okay, so we charge flat fees to do almost everything we do.
Oh, nice.
So to set up an estate plan for a married couple, we charge $22.50. Okay, that includes,
Totally reasonable.
oh, super reasonable.
Because
Okay,
I know when we bought,
Yeah.
when ours back in 2005 was
Oh,
almost
yeah,
$10,000.
wow, okay, so.
You're on
Raise
charge
my prices.
rate.
I mean, the
No,
nice
that's really,
thing.
no, I know they've come down because the need has really come up for families.
Mhm.
It used to be you didn't need this,
Yeah.
those kind of tools.
Well, we've always been very competitive. We're a small practice.
Mhm.
Our overhead is like $0 almost. But, and because of that, we just pass that on to our clients. I mean, we still make a ton of money on trusts, okay? But, well, that includes $20 to $50 for a married couple. That includes doing the trust, doing the wills, doing the powers of attorney for financial and healthcare, doing the trust abstract, drafting and recording the deed for your house, okay? If you have additional pieces of property that need additional deeds, we can get $250 for each of those. But that includes the recording cost, which is like $100 on its own, right? So that's what we charge to do something like that. If you're a single person, we charge $17.50. So, but the other things that we offer for all of our clients, just
I
hold
was
on one
gonna say,
second.
does that include the advance directive and the?
Oh, yeah, all that stuff. Yeah, everything we've talked about. So.
I will just say like that, just, I mean, that's why I brought you here, that I think you're good at it, but the process by which they take you through to fill out those forms is, it's almost very easy. It's like a questionnaire almost, and the healthcare directive, everything that you need done in the trust is done through a form almost, and of course you consult and get advice, but I will say, just to pat on your back, you have really dialed in the process of your intake. So it's like, it's not as hard as you would think.
Yeah.
You just want to finish it. You want to go to the banks,
for sure.
and you want to go like actually do the stuff.
Yeah.
But I will say it's pretty easy to like, and thorough, I would say.
Yeah. And the thing that I always tell clients is this is the easiest thing in the world to overthink.
Yeah.
Because clients are like, what if this happens? What if my kid decides he wants to be an astronaut? Or, just, like all kinds of crazy stuff that actually doesn't make any sense. But the simple truth is most people want the same thing. If you've got kids, you just want your stuff to go to your kids without going through probate in equal shares, And so it's very straightforward, very easy. And of course, we have complicated situations. We have clients who have, kids who are on Social Security disability and other things like that, where we do have to do quite a lot of tap dancing to make sure that we're not going to blow their benefits. And sometimes we have situations where we have, clients who have to disinherit kids, or they have kids with substance abuse issues and other things like that. And of course, we take care of that kind of stuff. But most of our clients just want the same thing. They just want their stuff to go without probate.
What about special needs trusts?
Okay.
Do you do those?
We do. Yeah, we do lots and lots of special needs planning for people. Now, typically, if we're going to attach a special needs trust to an existing trust, like if we're setting up a trust and you say, I've got a disabled child, and after I'm gone, I want that child's share to go into a needs trust, then we charge an extra $1,500 for that. If, historically, if we were doing a freestanding needs trust, like if we were doing Medi-Cal planning or something like that, we would actually charge $4,000 to do that, because that also included doing the stacked gifting and the other complicated stuff we had to do to get the assets out of the estate.
So for example, my example, that irrevocable trust that my father-in-law has,
Okay.
one of the beneficiaries is a special needs person up in Alaska. So the trust states that his share will go into a special needs trust once the father dies.
Okay.
So that would need to be set up. Is that something you could do?
Yeah, we could definitely set up something like that. I mean, the useful thing about that is, I'm assuming that the responsibility for that is, I guess, with your husband, who's the
With
successor
trustee.
trustee. Okay, so yeah, so that would be a person who have to set that up. But the useful thing is, like, all the terms are basically kind of set up, you know, which you
Right.
can do in a situation like that is you don't even need to necessarily have a separate trust document. You can do a trust abstract, say, referencing the original trust and saying, I'm the successor trustee, and I'm also the person for this needs trust. Here are the rules about the needs trust, and you reference back to the original document, so you don't even have to craft a whole new trust. So, yeah, there are a couple of kind of ways to skin that cat, so, yeah.
When you set the trust up, the power, like, because I have an 18 and a 22-year-old, and nobody has ever told me about the power of attorney with the kids. Never heard that.
Okay.
So thank you for that,
Sure.
because both my kids have assets now. And if something happened to them, I just tell them on anything beneficiary, just write the 2005 Gattenbein Trust. That they know it by heart.
Okay.
But, okay, if something were to happen to one of them, the assets would go to the trust. But if they were in a hospital, there's no power of attorney.
Right.
So
Yeah.
nobody could even get into any of their accounts to help pay for any of their expenses.
Yeah, for sure. Yeah, because that's the tough thing about beneficiary. is
Yeah, you
they
just
really
think as a
think about
mother,
that.
you're
It's
always
crazy.
a mother.
Mhm.
I mean, I want to cry.
I know, like,
Well,
yeah.
you wanna make medical decisions for
That's a
them,
bad
too.
thing.
Yeah.
Because I mean, I'm doing it for myself. I mean, I have a bank account in the trust, so if something happens to me, our successor trustee can go in and pull money out to pay the bills, to pay for everything, to keep the machine going.
Yeah.
But you just don't think about your kids.
Yeah.
Yeah,
You
I
just
thought
think
about that too,
they're
and I'm
yours
like, how
and-
are we gonna get to our kids and make them get it notarized?
Yeah.
I'm like, I'm sitting you down and we're going and I'm
Well, I
paying
think
for
when you do the
it.
trust, you just ask the attorney to do that.
Yeah, and I mean, just so you know, I mean, again, we charge flat
Yeah.
fees to do almost everything.
And
Yeah,
you
that's
take
a
them in
nice
to go get
service.
notarized.
I need to work like I talked to already. I knew coming in. I had to ask you that. For the AP
But to set up
part.
a powers of attorney, we charge
Oh,
$300.
yeah,
It's really
Yeah.
easy to do.
Oh, you can do that that way, okay,
Yeah, you know, that includes the notary, we take care of all that kind of stuff,
okay.
so, yeah.
And the kids sign it.
Oh,
The
yeah,
kids have to
Because
sign
they're the
it.
ones who are granting the
Yeah,
authority.
my 22-year-old might have problems with that.
Yeah, I mean, we have had situations where mom and dad like retain us to draft powers of attorney for their kids, and their kids show up and they're like, wait, why is my mom the agent of the power of attorney? I want it to be my buddy.
They
And
keep
it's
having to
like,
get their Apple ID.
you're-
Yeah.
Yeah, so that's, yeah.
So if you already have wills,
Mhm.
you already have POAs,
Mhm.
considerable health and financial, just bring those to you and you'll
Yeah,
do
yeah.
everything.
Yeah, we do free document reviews and we do free initial consultations. So we're happy to sit down with people and talk through all of this stuff that we just talked about.
Well, if we wanted to do a trust,
Mhm.
those components you said you do, but we already have those set up. You would
Yes, so we-
take those and,
Well, we would need to replace your wills because they're not horrible.
right.
And then, to be honest.
And
we almost
review
always-
everything.
We just do the powers of attorney. Yeah, right. Because one of the things that we see a lot of is there are tons and tons and tons of people out there who draft powers of attorney that are not what we call statutory powers of attorney. If you go into the probate code, there's a document there. And it's, you know, there's one for financial and there's one for healthcare. And if you use that language verbatim, then there's some additional protections that accrue under the probate code that you don't get if you just have a generic 50 state power of attorney. The most important of which is the ability to enforce it. One of the things that we're seeing more and more is we'll get calls from clients and they say, you know what? I went down to the bank because I needed to transfer some stuff from my mom and put some accounts into her trust or whatever. And they told me that they didn't want to accept that power of attorney, even though it was totally validly executed because it was more than 3 years old. And they're like, my mom has dementia. She can't sign a new power of attorney. What am I supposed to do? If you have a statutory power of attorney, you can ram it down the bank's throat. If you don't, you're kind of out of luck, you know, because,
Right, got it.
yeah, those protections only accrue to the statutory.
So is that due to like banks? Obviously, there must be some fraud going on. They want
Oh, yeah.
very current POAs.
Yeah, it's an internal policy of the banks.
Ah.
You know, there's nothing legal about
I
that.
can
It's
see
just
that
that
happening.
if you're Bank of America, you can kind of make your own rules, right?
Right.
So that's what's happening is, you know, their fraud department comes down and tells everybody, okay, I don't want you to accept any powers of attorney that are more than 3 years old or 5 years old. And so they come back to the clients, and of course the clients don't know any better. And they're like, oh crap, now what am I going to do? You know, fortunately, if they have, like we drafted, their statutory powers of attorney, and you know, we'll friendly letter to the bank and say, we're gonna sue you, and that's that, so, yeah. So, yeah.
Also, that trust abstract that you were talking about earlier, that summary, that came in so handy for us when
Oh,
we
it's-
had the, the father-in-law goes into assisted living, all of that. We had the long-term health care insurance. We couldn't send the whole irrevocable trust, it's 200 and something pages.
Yeah.
So that was very valuable. That's a very valuable
I always tell clients that we hope that the trust abstract is the document they use the most, because that's what you use to fund the trust. That's what you use when you're dealing with, anybody, basically. You don't want to give them a full copy of the trust.
Right.
So it winds up being a very, very useful document to have.
Thank you for that.
There's some firms that do trust abstract, and it's like, okay, whatever. So it's kind of tough.
So if you didn't want to put the trust name on all your bank accounts, would that abstract work if something happened? Would you be able to bring it to the bank, or do you have
Well,
to?
what you need to do, if you don't want to put your name, I mean, the short answer is no. You couldn't like come after mom was dead and say, well, look, she had a trust, so I want to take control of that asset. That's not a trust asset. You have two ways to fund stuff into a trust. You can either retitle it, or you can use a beneficiary designation. Of course, we just talked about beneficiary designations and some of the pitfalls of that. But one of the things you can do, and in fact, if you bank at Chase, this is almost the only way to do it, because otherwise they want you to close your accounts and open up new accounts in the name of the trust, is you just say, I have one beneficiary of this account, and it's my trust. Remember, the
So
trust.
that's a way to avoid having to go into the bank and.
Well, you still have to do a beneficiary designation. It's just that you make it the trust. Remember, the trust is a box. Everything's either in the box or pointed at the box. So 401ks, IRAs, life insurance, always pointed at the box. Sometimes you point your checking account at it. And that way, the nice thing is you don't have to change your checks. Nobody knows you have a trust, that kind of thing, if you care about that kind of thing. And, but then when the person passes away, the successor trustee goes in and says, I'm the successor trustee, here's a death certificate, that money can flow into another account within the trust.
So the bank statement will have your name, and then underneath it, it'll say POB, and the trust.
Yeah.
Yeah,
Stuff
it
like
just
that.
has like a T and a slash on it. with the
Yeah.
name.
So you
Yeah,
can-
I just
Nothing
wouldn't
even
want to
to
have,
tell.
I have a business, I wouldn't want to have to write business checks with all my trust.
So one question on that is, how's your business structured?
It's sole proprietor.
Okay, so it's sole proprietorship, yeah. You don't do that. So, but important thing, you could put an LLC into a trust. You could put the stock of your S corporation into a trust. It's basically a box inside of a box, right? So, and if you do that, if you have an entity and you put the entity into the trust, then the accounts that are held within that entity don't change. They stay inside that box, then the whole thing basically just gets dumped into the trust. But what that means is that when you pass away, now you've got somebody who can pay the bills, take care of payroll, do all the other things that are necessary to make sure that business doesn't fall apart. That's one of the dangers of having a sole proprietorship, is sometimes the person passes away and their spouse goes over to the bank and says, yeah, my spouse passed away, he has a business account with you, and they're like, again,
Right.
and they can't get hold of the assets. So, yeah, you had a question, right?
Yeah, you said you can't put retirement income into a trust.
We can put the income in, but you don't change the ownership of an IRA or a 401k or a 450.
How about like a pension or something?
Okay, so pensions, all you have to do is you just use your beneficiary designation. The funds can flow into the trust, but anything that's tax deferred doesn't get changed title. It has to be in your name as a person. Because if you try to put it into a trust, that's an immediate tax recognition event for the whole thing. That's a really bad idea. So use your beneficiary designations. But once the money comes out of that IRA, you can put it wherever you want. And we would suggest you put it into the trust so that if you're accumulating money, then you can not have to go through probate. Yeah. So one other thing that we never did talk about as far as what happens if we have assets that aren't in the trust. Let's talk just for a couple of minutes about what that looks like. So let's say, because we see this a lot, somebody will set up a trust, they throw their house into it again, they sell that house, they buy a new house, they don't put it in trust, and they die. Now they've got a house that's not a trust asset, which means it's a probate asset. So the tools for getting stuff into the trust are a well-crafted Schedule A and a pour-over will, right? Now, depending on the value of the assets, we can avoid going to the court, okay? So the threshold for going into probate in California is if you have, again, any real estate with a gross value of more than $62,000, or if you have any other assets with a value of more than $184,500. It's a dumb number, but that's what it is. And it used to be $100,000, but And so, if you're under that, the most common thing we see is people will call and they'll say, you know what, my mom set up a trust 20 years ago, everything was in a trust except for 2 accounts that she set up last year, and for whatever reason, they told her not to put them in the trust. One has $50,000 in it, one has $20,000 in it. We're not up to our threshold of $184,500. So in a situation like that, you don't have to go to court because you're not hitting the probate threshold. What you do instead is you can draft what's called a small estate affidavit, okay? And it's basically a document that you sign under penalty of perjury saying the total value of this person's estate that would have gone through probate, because remember, everything in a trust is outside of probate, is under $184,000, therefore handed over. It's an affidavit, you sign it under penalty of perjury, we notarize it, you have to notify, it usually has to be signed by the executor of the pour over will if there's a trust. But by doing that, you can take that to the bank, and the bank will send it off to their legal department, they'll review it, and as long as we did it right, they will cut a check in the name of the trust to that person. So you don't have to go to probate to do that. Okay, let's say we're over that. Let's say we're talking about a house. Let's say we're talking about a bank account with $500,000 in it. Then what you do is you do have to go to court because you're over your thresholds. But what you file is what's called an 850 petition, what's called a Hegstead petition. It's called 850 because it's probate code section 850. But the idea is, again, you can do that same thing. You go to the court and you say, look, here's the trust. Here's the pour over will that directs that everything should be in the trust. Here's a good Schedule A that says all of my assets should be trust assets. And we get an order from the court saying all of these assets should be trust assets. And then you can take that order to the bank, to the financial folks. You can record that as a deed. And by doing that, that's what you use to close that gap in the chain of title so the trustee can then take over those assets. Now, you have to do an 850 petition in the probate court in the county where the person passed away or the county where the trust is being administered, usually the same thing. But it's way, way better than going through a full-on probate. So you remember how we were talking about the probate fees, the statutory fees? To do an 850 petition right now, we charge $3,500. Okay, so it's way cheaper than a probate. And typically, it's a one and done kind of thing. You file your petition, you notify everybody just in case some weirdo is going to come out of the woodwork to contest it. And then you have one hearing. And as long as everything was good, the court says, okay. And they stamp the order, and now you've got the order that you can use to get a hold of those assets. So it's significantly faster than a probate, and it's significantly cheaper than a probate. So it's kind of a post-death cleanup tool. That's where we use the pour over will. That's where we use a good Schedule A to get a hold of those assets.
You said that takes about a year?
No, usually right now, like we have a couple of those going on right now. Right now, we're filing and we're getting on calendar in about 3 months.
Okay,
Yeah.
the regular probate.
A regular probate, we usually say between 8 months and 2 years.
Yeah.
And it's
Under COVID, it was much.
Oh, during COVID, it was way, way worse.
Yeah.
One of the things that's nice that's happened in Sacramento County, I don't actually know it, we live in Placer County right now, right?
Yes.
So to be honest, I
Moving a little
don't
bit
really do
faster
probates
today.
up here, but down in Sacramento County, it used to be that we would get on calendar, we would file a petition, we wouldn't get on calendar for about 6 or 7 months. For the first,
So what is a family supposed to do? Like,
that's a great
it is
question.
so sad because
trust.
I just recently, went through a death in the family, and I was a beneficiary on an account, but I couldn't get access to the money in the account. So I was explaining to you, because they were just being lazy and didn't want to transfer the money over. But I had assets to pay for funeral expenses out of my own money.
Mhm.
I just don't think my dad realized that being the beneficiary would take so long, but he also knew I had the money. But if you didn't have the money and you had to pay the SMUD bill or you had to pay the property taxes, I could just see the dominoes coming down on
Oh, for
that
sure.
so
That's
fast.
the most common is they start to have to incur the cost out of pocket.
Oh,
And sure, they can get reimbursed with proceeds, but if you don't have the money out of pocket,
You're in trouble.
you're in
Yeah.
trouble.
I mean, like right now, we started a probate a couple of months ago. But the one nice thing that's happened in Sacramento County, used to be we were looking at 6 months to get on calendar. They actually added an additional calendar date or hour. It used to be we only had a 9 o'clock calendar, now we have a 1:30 calendar. And that has significantly sped things up, which is great. Now we can get on calendar in about 3 months. But we've got a probate that we're working on right now where we had a client who came to us and the client's mom passed away and she had one asset, which was a house, and it has a reverse mortgage on it. And the challenge they face is the reverse mortgage company people still have a lien on that house. And they want to foreclose. Starting a probate does not stop a foreclosure. So that, I mean, we have seen properties get lost in foreclosure just because it takes so freaking long to get through probate. And nobody in the family had the ability, the financial wherewithal to get that done.
Because if you have a reverse mortgage and the owner is no longer alive, they want that property sold or.
Yeah,
They
100%.
get notified by the
Yeah.
death certificate, like that.
Yeah. So they'll jump on it, and quite frankly, they don't care. You know, I mean, there are lots of times where the client will call and be like, oh, my mom just died, and, you know, we're gonna go to probate, and they're like, okay, well, just realize that, you know, we're not gonna stop what we're doing just because, you know, your mom died. So that's again, another reason why you definitely don't wanna go to probate if you can avoid it, you know, and so it's good idea to have a trust.
What questions have we not asked yet?
Let's
So the one about the, is this a federal document or is it county or state?
Okay,
What is it?
so trusts are creatures of state law. Now, the trusts that we draft are designed to work in all 50 states. We have clients who own properties all over the country, no problem. And if they decide to move, they can still take their documents with them and they'll still work without modification. The one thing that we would have them consider looking at doing is new powers of attorney, simply because those are state by state specific, and especially if you want them to be statutory and have those same rights, you might want to consider doing new powers of attorney. But we've had clients, I mean, where we live, you know, over in El Dorado Hills and over by Folsom, you know, we have tons and tons and tons of Intel clients. And, you know, they get transferred all over the place and they just pack up and leave. And so we've had clients take our documents everywhere. And we've had clients who own property in Florida, we've had clients who own property in almost every state in the country. And so that's fine. You know, the documents are durable documents, they are portable documents. You know, we usually say, you know, you might want to look into whether or not your powers of attorney will work. They almost always do, but there are lots of times where just to be 100% safe, we'll suggest that they get POAs in place.
And how long does it take, if probate takes 8 months to 2 years, how long does this take to disperse the money?
You could do it in a week. Yeah, because the important thing is the successor trust, if everything's funded into the trust and it's straightforward and simple, then your successor trustee goes to the bank with a death certificate and takes control of the accounts, and then they can start cutting checks. You know, typically, if you've got multiple beneficiaries, it's always a good idea to do some sort of an accounting to say, okay, here are the accounts, here's what's in them, here's the money, let's do some rudimentary math, there are 3 of us, so let's 0.33, and they can basically say, so here's your share, as long as everybody's like, yeah, that looks great, cool. You know, a successor trustee can immediately put a piece of property on the market and, you know, and go ahead and sell it right out of the trust, and then have the proceeds go into the trust, and then just disperse those. Or sometimes what happens is people are like, well, we don't really know what we want to do, so why don't we just give the house to the kids? And then if we decide we want to sell it 2 years down the road, they can do that too. The difficulty with that, of course, is thanks to Prop 19, the house is going to get reassessed in a situation like that. It used to be between parents and children. We didn't have that rule, but of course, now in order to qualify for Prop 19 for a parent-to-child reassessment exclusion, it has to have been the personal residence of the parent, and then when it comes down to the child, it has to come down to one child who makes it that person's personal residence within 1 calendar year. So, yeah, so, I mean, I don't know, I'm talking to a bunch of real estate people, so I don't want to slag on Prop 19 too much, but what a freaking snow job.
Do you have a
So, anyway.
business card for us?
What?
I
Do you have
sure
business
do.
cards for us?
And also, I
Oh,
was
yeah,
gonna
Eric's
send
got
an
some,
follow-up email to everyone who came, and then I'll include your contact.
Yeah, that'd be great. So yeah, but Aaron's got some business cards if you want to grab a business card. And like I was saying, I mean, we do free initial consultations. We're super happy to talk to people.
Aaron.
And, you know, but the other thing is, like, especially for our existing clients, we never charge for phone calls. You know, if you've got a question about something, please call us anytime, you know. And, yeah, because almost certainly going to be something I know off the top of my head. And I'm always happy to answer questions because, of course, that's a great way to generate goodwill in the community, so to speak. And, you know, but at the same time, we want to make sure that we're of service in our community. And, you know, so if there's any time, like if you've got a client you're working with, or if you just have a question about your own family situation or anything else like that, we want to be a resource to you guys. So, is that all set time?
So in a nutshell, on average, it costs $6,000 for probate, on average, 5, 6.
Oh, it's gotta be more than that.
It's got to be, let's say 25.
Okay, or
Or $22.50
$3,000
to do a trust.
basically
Yeah,
to get the trust set up.
right.
Well, if it's
Right.
4% of the first 100,000.
Oh, yeah.
And
I mean,
it's gonna be a lot of
Oh,
money.
it adds up fast, you know. I
like
mean,
most people object to the trust because they say, oh, it's
Too
expensive, right? But I mean, to me, it seems,
Can I ask you why you haven't put your, bank accounts in? Is it because you have to?
I have not prioritized it. It has not been, yeah, it should have been a higher priority.
Let's all beat up on Steve now.
Yeah. We have totally lagged on that. We've had appointments set 3 different times and I'm the one that cancels.
I'm just saying.
And they're still growing, they're still growing, you gotta wait until they get the trees full, then put it in.
So we got a question back here and a question over here.
You just create appointments at your banks and then you need to go to the bank. But I was gonna call the bank and see if I can just make the trust a beneficiary. That seems like an
You can do
easier
that
way.
too. Yeah, I mean, to be honest, it's the same amount of work, it's just a 1-page form.
But then
Yeah.
it's,
There you go.
if you die, it's like we're on joint ownership. So if I die, my husband can take my money right out. So is it that simple with the trust?
Oh, yeah.
Okay.
It's clearly stated.
It's
If
very,
you
very
wanna make it that way, it's clearly stated.
Okay.
Like I said, the forms, he created like a really nice form that asks you, well, what do you wanna do with X? What do you wanna do with Y? And so it kind of takes you through the journey of what you would want to do in certain scenarios.
That's very true.
Yeah.
Okay, questions in the back?
Theoretically,
Mm-hmm. Oh,
you
yeah.
have in-laws who
Okay.
don't own a home.
Uh-huh.
Their assets, which I consider liabilities, are 2 vehicles,
Mhm.
jewelry and furniture and
Okay.
dogs.
Okay. So they're probably not anywhere close to the probate threshold, right?
Probably not.
Yeah, so that being the case, I mean, they should definitely have powers of attorney just in case they become incapacitated. And then depending on where they want their stuff to go, they could just say, you know what? If I just wanted to go to the kids in equal shares, that's what the Intestacy Laws say.
And I believe they have a will.
Okay, that's great. I mean, and that could be the document that you guys use to draft a small estate affidavit after they're gone. And the executor under that would basically say, hand the stuff over, and then the executor could distribute the stuff to the people who are supposed to get it. So, yeah.
So if beneficiaries get a benefit of something, does that open them up to have all the creditors come after these people as well?
Okay, and the short answer in that situation is no. You don't inherit debt, okay? Debt has to be paid by the estate prior to it going to the beneficiaries. But let's say that somebody doesn't do that. Let's say that you've got a situation where, like, mom dies, she has $100,000 of debt, $200,000 of assets, so they distribute all the $200,000 down to the kids. Those creditors could come down to those kids and be like, you gotta give it back. You know, they can claw those assets back, and that is, especially, like, let's say they took that money and they put a new roof on their house or something like that. That could put them in a really unpleasant situation. So debt, creditors are always entitled to be paid first. So that is one thing when you're doing an estate administration, is to figure out what those debts are and make sure those are handled first. Now, having said that, let's say that mom's estate is $100 and she has $200 of debt, so it's underwater. The creditors can come get that $100 of, of assets, whatever there might be, but they can't then go down to the beneficiaries and say, you each need to give us $25. It just ends at that level because you're not responsible for your parents' debt, except for the degree that you take assets from them that should have gone to creditors. So super important on that.
And you have to pay the taxes for that calendar year and the following.
Oh, yeah, when mom and dad dies, if they have income, somebody's got
You have to
five.
make sure all the taxes are taken care of. Don't start giving money away until all those taxes are paid.
So there's pressure right here.
So I get the benefits of putting everything into a box for when I die and for the benefit of my heirs. Is there any tax benefits of setting up a living trust while I'm alive?
Tax benefits?
Yeah.
Not really. I
No.
mean, it'll make sure you get your stepped up basis and other things like that when you pass away, but other than that, it's basically transparent. You'll still get all the same tax deductions that you might have had, but you're not gonna get like an additional tax benefit on that. You're not like diverting income or doing other things like that where it might wind up being paid at a lower rate.
Well, the one nice thing you will get is if you don't put your last name in the trust and somebody tries to find where you live, they won't be able to find it.
Yeah, there's a lot of,
Like, cause if you
days
name
like
it,
scratches.
What do you mean again?
well, like if you name it the 2024 and take your initials trust,
Yeah.
that's the title on your house now. So if somebody goes on Zillow or something and starts typing in looking for your name, it's not gonna come up.
I'll find it.
You got Ada. You got Ada. You can call Ada.
Two things to say on that. The first is that the full name of the trust is the such and such trust, and then your names as trustees. The second thing is that if you're putting in an existing trust, they just have to go back one deed there's your names right there.
Yeah.
So, I mean,
Yeah.
we never tell clients to like count on people not being able to find your assets if they're in a trust. 'Cause
Oh, I was
there's
just
a
thinking
whole
not
chain
being
of
able to
title.
find you, I wasn't thinking looking for money, we
Yeah.
were just.
But no, we definitely put the trustee's name on the deed. Because,
I thought mine's on title is the 2005 Gattenbein Trust. It doesn't say Michelle and Eric. But on the deed down below, it shows that.
when you say the deed, you mean the deed
Well,
prior to that?
the full name of the trust, but the actual deed that comes up on title
Mhm.
is the 2005 Gattenbein Trust. But if somebody typed in Michelle Gattenbein, I don't think that would come up.
But if they type in Gattenbein,
Yeah,
so, yeah, I mean, don't count.
yeah,
Yeah,
I know,
yeah.
well,
They'll find.
AI, you'll find it.
They'll definitely find it.
Yeah.
Yeah, it's not hard to find assets. I mean, obviously, I don't do litigation, but litigators have people that they
oh,
like
yeah,
skip
no, I
tracers and
wasn't
all
trying
people
to
like that,
speak.
they'll find all your stuff.
Your boyfriend trying to find.
So, yeah.
Does the trust company help, the executor of the estate, not make any errors accidentally?
So when you say the trust company, I mean, are you talking about us?
Yeah.
Like our firm?
Yeah,
We do.
call you.
Yeah, we
someone
do
asks
trust
for it.
administrations. So like, yeah, after somebody passes away, we do free post-death meetings. We're happy to sit down with the successor trustee and say, here's what being a trustee is about. Here's some things to
Yeah,
do.
executor.
Yeah, here's
Very
a,
complicated.
oh yeah, yeah, you know,
Now you're scaring me.
we can put together like a laundry list of things that people need to do. Most of them you could do yourself. There are a few like affidavits of death and other things like that you might need our help with. We can also put you in touch with somebody who could help you do like a really good solid accounting to make sure that when you send it out to your beneficiaries, they're not like, what the heck is this? You know, so, I mean, one of the things we always tell clients when they're trying to figure out who they want as their successor trustee is we don't expect our trustees to be experts in everything. We don't expect them to be experts in real estate or taxes or law or any of that kind of stuff. They can hire people like me, a CPA, a good financial person, you know, to handle that kind of stuff, right? What you want when you're looking at a trustee, first of all, it's built into the name. Somebody you can trust, right, to try to do a good job. Somebody who's honest, somebody who's going to do what you said they're going to do. And they can, you know, of course, they should be a reasonably intelligent person. But beyond that, they can find the expertise that they need to be able to do a good trust administration. So, yeah. But we do lots and lots of trust
That was
administration.
a good question.
Yeah,
So when
so,
someone passes, you guys.
Yeah, we definitely
First call.
take care of those kinds of things. You know, because that's when we sit down and say, okay, you know, how'd they do? Did all the assets get into the trust? Or we need to do an 850 petition? Or, you know, what do we need to do? You know, and of course, every situation is going to be different. And so, you know, we'll put together that list and, you know, just figure out who's going to do what.
Very good.
It's 3 o'clock time. Yeah, that was quick.
Thank you.
Yeah, thank you.
Good job, you guys. Thanks so much for the questions. Yeah.
Thank you.
I mean, it's always nice when people have lots of questions. There are times where I'll do presentations and it's just like talking to the dead. And you're like, we're still here, right? Yeah, I mean, but yeah,
You
lots of
are
good
a real
questions.
estate office, so it's always fun.
Yeah, exactly. So, all right, well, cool. Well, we'll stick around for a couple minutes just in case you have any other questions, and then, but thank you so much for coming. Thank you.
Yeah, I'll send you,